Got lots of space on your thing today?
All right. Roll call order.
Thank you very much. You may be seated. Kern-Fuller, you were going over your objections. Can you refer to the page that we're on? I lost my place.
Yes, Your Honor. We were at page 269, beginning at line 14, going through page 276 at line 13.
269, you said?
269, starting at page 14, line 14.
Give me a moment to get there, and then yes, ma'am, I'm there.
Your Honor, that testimony from page 269 through page 276 at line 13 has been designated by the plaintiff. That testimony involves an issue at Caters Lake in Anderson, and it's our position that it's irrelevant as reputational harm in this matter was removed when the counterclaims were recently settled with the Insurance Reserve Fund. Your Honor, when we came for a hearing in front of Judge Maddox over these same sorts of allegations, at that time, the plaintiff said that the reason why those things were an issue was because of our backup claim of anticipatory breach of contract if they were successful in their main claim of rescission. Since then, Your Honor, they amended their complaint, we amended our counterclaim, we removed the anticipatory breach. When we came in front of Your Honor on our motions in limine and on the summary judgment motion, they said that the reason why these issues were pertinent was because our counterclaims, which have now been settled, brought reputational harm as a damage. Now, the argument, I believe, will be my client's credibility. Your Honor, this is a moving target. This is a contract claim. The contract claim is at the time in 2008, on November 18th, when these council members, the 5 that voted for Mr. Waldrop, who abstained, versus Ms. Wilson, who voted against it, that those 5 members at that time did what they do was arbitrary and capricious. That's what they've alleged. Your Honor, this is a very high standard, as you know. They have to prove beyond a reasonable doubt that those 5 individuals who cast affirmative votes acted in an arbitrary and capricious manner. Not that they were wrong, not that 4 years later we come back and Monday morning quarterback them based on facts we've learned since, but at the time they cast their vote, was it arbitrary and capricious? That's their claims. Our counterclaim is simply, did they breach the covenant not to sue? This is not a relitigation of anybody's divorce issues. It's not a $2.5 million investigation so that certain members of the public can talk about something that happened 6 years ago, Your Honor. What I believe they want to do is to litigate a case within a case, and that's not what we're here. And under Rule 608, we believe that that it is proving a collateral matter by extrinsic evidence. And Your Honor, I would like to hand up case law for the court's record on that issue. The case is Gazelle versus Glover. Does Your Honor have a copy of that? Your Honor, before I pass it on a copy, it says, we believe extrinsic evidence can be oral or written, as it is the source of the evidence that determines whether it is extrinsic, not whether it's introduced in oral or written form at trial. Rule 608 permits questioning about the underlying event from the actor of the event. and not rumors or reports of what others perceive about the attack. Your Honor, we would also hand up Rule 608 and the notes to Rule 608. Rule 608B prohibits using specific instances of conduct to attack the credibility of a witness. And Your Honor, the notes to that rule say, no South Carolina cases have been found which permit cross-examination regarding specific acts to show untruthfulness. The use of specific acts to attack credibility is similar to prior South Carolina case law, which allowed a witness to be cross-examined about prior bad acts if they constituted crimes of moral turpitude. The cross-examiner was required to take the answer given by the witness and could not use extrinsic evidence or other testimony to prove the bad act. Additionally, the inquiry could only go so far as to bring out the general nature of misconduct and could not go into specific details. And that's a cite back to State versus Outlaw in 1992, and also cite State versus Major in 1990, State versus McGuire. Your Honor, Gazelle is a 2002 case when the South Carolina Supreme Court was authored by Chief Justice Toll. Also, the second note says that subsection B, like its federal counterpart, does not set forth what conduct may adversely affect a witness's credibility. The former case law standard, which allowed impeachment of the conduct of a crime as moral turpitude, is not the appropriate standard in light of the court's decision to abandon the moral turpitude standard under Rule 609. Instead, the trial court should be guided by the decisions of the federal court, which limit inquiry into specific instances of misconduct which are clearly probative of truthfulness or untruthfulness, such as forgery, bribery, false pretenses, and embezzlement. This will reduce the kinds of misconduct which can be inquired into from that permitted under prior law. Further, this rule, like the prior case law, does not allow a cross-examiner to go on a fishing expedition in the hopes of finding misconduct. So, Your Honor, it's our position that their assertions about whether or not Caters Lake was an investigation or was not, whether or not there was any sort of inappropriate relationship, is not the case in front of Your Honor. The case in front of Your Honor is a contract claim. They've asked for a rescission. They've accused 5 council members of acting in an arbitrary and capricious manner, and a counterclaim for a breach of the covenant not to sue. Your Honor, we believe that Caters Lake issue is not relevant to this matter, and we would ask that the court not entertain this kind of testimony or evidence as extrinsic evidence.
Thank you, Your Honor. We believe that Mr. Preston has made his credibility a central issue in this case, and he has also made the political climate of Anderson County a central issue in this case. And what he'd like to do, I believe, is present you a one-sided view of that political climate, casting himself as the victim of investigations and inquiries by certain county council members into his conduct as the county administrator. In this case, Your Honor, he says, among other things, that there was no pro quo between the votes in favor of the severance package and the and the things that Mr. Thompson got in exchange, for example. He says as a defense that he has no ability to repay. If the court were to consider rescission, he's given an affidavit to the court saying he has no ability to repay the funds. And so we think that those issues have been made central by the defendant. This was not a collateral matter. We would submit that the more appropriate rule, if one has to be looked at, is for credibility, Your Honor, that's all. I mean, he's going to, we suspect.
The credibility of every witness is a question. There are certain rules by which you can challenge that.
That's right. Yes, sir.
That's what we're talking about. We're not just following the rules, allowing you to challenge.
Yes, sir. And on that note, I mean, the anticipatory breach counterclaim, yes, has been withdrawn from the pleadings, but it's not been withdrawn from the facts presented in the case because they have elicited the testimony from several county council members asking them why they voted in favor of the severance package and trying to rebut our argument of arbitrary and capricious, which we agree we have the burden of. But they are trying to rebut that evidence by saying it wasn't arbitrary and capricious at all. It was entirely reasonable. Why was it reasonable? Because it was a toxic political environment. There was a lot of harassment going on with Mr. Preston, which they cannot tie to any particular county council members. That evidence has been allowed, and that's fine. But what they're not allowing is the evidence that shows there were good reasons why certain council members were suspicious of Mr. Preston. They were trying to find out more information about how finances were run. They the finance department tried to get credit card receipts and were rebuffed. That was a legitimate dispute, we understand, between those council members and Mr. Preston. He sought court intervention about that. We've heard testimony about that as well.
And the court intervened.
What's that now?
And the court intervened.
Yes, sir, that's right, and that matter has been resolved. And the testimony they elicited, Your Honor, from the notes of Mr. Bright, had 3 different council members talking about the fact that there were issues of concern about whether or not Mr. Preston might be having an affair with a subordinate employee. That's part of the so-called toxic environment that was going on. The harassment they elicited included a letter that they presented, Your Honor, in March of 2006, which is at the time of the case date. And it included harassment not just of county council members, but also of Mr. Preston and of the employee with whom he was alleged to have had an affair at that time. We also know, Your Honor, finally, that they offered...
Let me cut this a little bit short. Perhaps I'll cut it short. Maybe I'll engender additional discussion and see. I took the time out to read the entire portion of the transcript that's being challenged because I have not seen it or read it prior to this time, and I have read it now. It does appear that what's taking place is questioning concerning an event that allegedly occurred at a place called Gators Lake. I believe that's a park. I come in past on the way in. I observed that coming in this morning. Anyway, and at this point in time, I don't find any effort in this transcript to impeach Mr. Preston. It seems to me that you're asking questions about his version of what happened on that particular occasion. And I do know and agree with Mr. Preston's attorneys that Rule 608 limits what you can go into to attack someone's credibility. And there are rules limiting the ability to attack someone's credibility on what is called collateral matters. This particular issue is kind of on the edge as to whether or not it's a collateral matter or it isn't a collateral matter. It's an interesting question. But at this point in time, am I correct, Mr. Tessier, in saying this testimony, it doesn't attack the credibility, or it's not an effort to impeach? I think it's an effort to get the story on the record from which you may later try to impeach. Is that what I'm hearing?
I think that's a fair way to put it, Your Honor.
All right. You agree with my assessment of what's about to be offered?
Yes, Your Honor, I agree with your assessment. I did want to note 2 other objections we would have to it.
Yes, ma'am.
One is under the Bear Enterprises case, and the second objection is under Rule 403, because probative value versus prejudicial value. Your Honor, I would also...
I would expect in all cases to do that evaluation. Go ahead.
And also, Your Honor, the argument of the plaintiff that for somehow Gators Lake caused them to question financial transactions of credit cards, but they have shown no nexus between any credit card or any financial transaction of the county that was linked to Gators Lake. So that's the other issue.
Well, as in a lot of cases, it's difficult to get the proof in the right order. And normally, if a jury were sitting here, we might do this in the form of a proffer. But at this point in time, I'm going to rule that the evidence in question is challenged. I'm not making a ruling at this point in time. I reserve my right to make a ruling, as I have the right to do, until such time as I feel like I have sufficient information to make that ruling. I will allow the presentation of this evidence into the record in the form of a proffer at this point in time. And once I've heard the evidence or testimony of all witnesses, I will make a determination as to whether or not it has any value either as proof of any matter in controversy or has any value under the rules for impeachment purposes. So I'm reserving that ruling at this point.
The next issue...
And let me explain to you. One reason I'm doing that is because thus far my review of the evidence indicates that while there were 3 councilmen in Mr. Bright's notes who mentioned the question of affairs as a consideration or an issue that was being bandied about in the public at that point in time. The only evidence I have from the councilmen who were on the other side of that decision was the testimony of Mr. Walter and perhaps the notes that were taken by Mr. Bright from the other two councilmen who were opposed. And I have not heard any of them use this particular issue as a reason for what they did or how they acted. So I find it a little questionable in that regard at this point in time as well. Of course, we haven't had all that evidence presented. That's the reason I'm reserving my decision.
There's one last item, Your Honor, which is beginning at page 277 and going through page 278, where there were questions about whether there was an inappropriate relationship between the county administrator, subordinate, and employee. And we would object because, again, it's irrelevant because reputational harm has been removed from the counterclaims. Additionally, Your Honor, they don't have a defense of after acquired evidence. This is not an employment case where they're saying, you know, had we discovered this at the time, we would have terminated them, we could have done that. That's not what their claims are. That's not what their defenses are, Your Honor. And there was additionally never a claim made while Mr. Preston was the county administrator or after. And any claims that could have been made since his employment ended on January of 2009 would be out of statute. So the only purpose of putting this speculative information in the record is just an embarrassment factor, and we don't think it's relevant to the claims that are at issue.
Really the same argument, Your Honor, for this piece of testimony as it was for the other, and I'll stand on that argument.
Yes, sir. Again, my focus of inquiry as to the arbitrariness or capriciousness of the decision made in this case, my focus will be on what occurred on that particular event. And of course, I've already said that whether or not this constitutes collateral evidence or proof on any fact that's in material fact that's in controversy is a fine line, nebulous at best at this point in time. And for that reason, I'll again reserve my decision on that matter until such time as I've heard all of the evidence in the case. Anything further that we need to discuss concerning this matter?
Not on Mr. Preston's
And
testimony.
Not much, Your Honor. Yeah, well, yes, sir, and I think I made this clear already, but we've included certain excerpts that we object to, just included them with the notifications that we gave you that you can sort that out. I think we've got this where it needs to be, so it's approximately 4 hours. Yeah, we're ready to play. I just wanted you to just tell us anytime you want us to stop.
I'll tell you, if you caution me about how long it's going to be, I'm aware of that. But we're here to try the case. I'm here to do it. So let's get it started. Anything further? All right, you may begin to publish the deposition. We may stop for lunch in the middle. I suspect we will.
Can you tell us your full name for the record?
It was Joey Ray Preston,
And where were you born?
Winston-Salem, North Carolina.
What was the address at which your family lived when you were born?
330 East King Street, or Main Street. They changed the street name.
Is that in Winston-Salem or different town?
King, North Carolina.
And how long did you live at that address, approximately?
21 years.
So you grew up there, basically? Is that fair?
Yes.
Where did you go to high school?
South Stokes High School.
Where do you currently reside?
2835 Old Williamston Road, Anderson, South Carolina.
Who lives there with you? Anyone?
My youngest son,
How old is he?
13.
Okay. You have other children besides the
Yes.
13-year-old? Who are they?
William?
Is that it?
Yes.
So two sons?
Yes.
Is William over 18?
Yes.
Is he in college?
Yes.
Is the property at Williamson Road in your name only now?
No, it's still in both names.
After high school, did you go on to college?
Yes.
Where did you go to college?
University of North Carolina, Charlotte.
Did you graduate?
Yes.
What was your degree in?
I have a bachelor's degree in political science and psychology.
After high school, did you go on to college?
Yes.
Where did you go to college?
University of North Carolina, Charlotte.
Did you graduate?
Yes.
What was your degree in?
I have a bachelor's degree in political science and psychology.
And what year did you graduate from college?
1986,
What year did you graduate from high school?
1981.
Did you go directly to college
I
after
did.
high school? Took 5 years to finish the joint program?
Yes.
And what did you do after college?
I went to graduate school.
And did you get a degree?
No. Yes. Well, later on I did, not there.
So immediately after you graduated in 1986, you continued on into a graduate program?
Yes.
And where was that?
University of North Carolina, Charlotte.
And what were you studying?
Public administration.
And you did not finish the degree, at least not immediately, is that fair?
I went to work.
Were you taking the classes while you were working?
Yes.
When did you ultimately get a degree, a master's degree?
I have a graduate certificate from Clemson, not from that.
And the graduate certificate is in what
Public
field?
administration.
Is that, just help me out because I don't know, but is that short of a master's degree?
Correct.
And I take it you've not continued your education sufficiently to obtain a master's degree in public administration as of yet? Where did you go to work after you graduated with your BA in 1986? Where did you go to work?
City of Charlotte.
Did you go immediately to work for the city of Charlotte?